It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Yeah, horse smells on my voicemail like a butler hanging on my coattail. Got these chickens clucking like it's H-Mart. Writing poetry, got it for wholesale. Ringing doorbells with these CDs on me going hand in hand. Got a bag, then I fumbled it. Fourth quarter board was looking like Shanahan. Now I'm stacking up them dividends. G's on me like I'm Dabba Dan. Pockets bulging like them hammer pants. Legendary like I'm Bag of Vance. Turning down these labels bad advance. Ooh, I'm feeling like a prize. You can see it in my eyes. Ooh, text on my number, won't get no reply. I shake them like grease on the fries. Chain swinging like a clock tower. Yeah, I'm suited up, Mr. Hightower. Feeling groovy, boy, monster powers. All this gold shining like a brighter shower. New kicks, I am not a punter, but the numbers running like I'm Jackie Joyner. Turn my words into fine art. I just drew a reference back to Magna Carta. Warming up like a leather bomber. Now they blowing up my phone. I just went to a safari, now they keeping tabs on me, Google Chrome. Down payment on a home. Got the paper making songs. See these suckers about to come in now. Cleo leave a message at the tone.
Shut up. The fuck? Your fucking kid and play high top looking ass. Getting on my goddamn nerve looking ass. Shit. Piss me off.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. Big shout out to Juana from X. All right. She came through and informed me that the transcript from the hearing that happened on June 30th regarding Drake and UMG, the transcript is now out, where the lawyers actually got to make arguments in front of the judge on the merits of this case, whether or not it should be dismissed, all of those different things. And I'm going to go ahead and just let y'all know the judge was cooking. Now, I ain't going to say that the judge wasn't cooking UMG, they lawyer, but they lawyer at least had good rebuttals that made the judge think. Now, as for Drake's lawyer, the judge was motherfucking fried rice in his ass. I don't want to just come in and create a whole thing, because I know there's a lot of people at very high emotions, a lot of narratives that are going around, a lot of people online that are, just grasping at straws to try to find angles. I'm not really trying to partake in any of that. I read through this before I actually even came to it, just to get an understanding of what was going on. But I must say, the judge was definitely cooking Drake's lawyer. And that's not because I'm anti-Drake. We're going to get into the actual conversation. This may take me a nice little minute to get through. There's 53 pages in this transcript. So if you showed up here, I'm hoping that you came here for the duration. All right? I ain't going to waste too much time. Let's get into it. All right. So, case called. We got the judge here. This is Judge Jeanette Vargas, which if you saw the thumbnail, that's the lady on the left side. So here, a case called Mr. Gottlieb. Gottlieb is Drake's lawyer. Ransom is UMG's lawyer, all right? This is going to be very vital information for the duration of reading this transcript, so you know who's on whose side. Gottlieb, Drake. Ransom, UMG. So Gottlieb says, "Good afternoon, Your Honor. Mike Gottlieb from Wilkie, Farr, and Gallagher on behalf of plaintiff. With me at counsel table are Brady Sullivan and Anna Gottfried." All right. Ransom comes in, says, "Good afternoon, Your Honor. Roland Ransom for Sidley Austin on behalf of defendant UMG, and with me today from Sidley are Nicholas Kroll, Caitlin Everson, and James Horner." The judge says, "Good afternoon. We are here today to hear oral arguments on defendant UMG Records' motion to dismiss the complaint filed by Aubrey Graham, popularly known as Drake. So let me outline how I'd like to proceed this afternoon. Since this is UMG's motion, they're going to argue first, and then I'll hear from plaintiff's counsel, and then I'll allow UMG to have a rebuttal. For the sake of the court reporter, I would appreciate if counsel would speak at the podium today." All right? So UMG is going to plead their case first. Drake's lawyer will come in, and then UMG will have a final rebuttal. I do want to let everyone know that I have reviewed the amended complaint that's from Drake, the documents that were the subject of the request for judicial notice, and the party's memorandum of law. So you should assume in your arguments my familiarity with those materials and the arguments of the parties to preview for you my specific concerns and what it would be most helpful for the court for you to focus on. There are a few issues that I would predominantly like to hear from the counsel in today. The first of those is whether or not I can make a legal determination at this stage in the proceedings as to whether or not the statements challenged as defamatory in Kendrick Lamar's lyrics are fact or opinion. Now, of course, this is a large part of UMG's rebuttal and their motion to dismiss. They feel like Kendrick's lyrics are all opinion, all right? Hyperbole. Second, if it is appropriate for me to resolve that on a motion to dismiss, whether and to what extent I should consider the documents submitted by defendants in their request for judicial notice in making that determination. And finally, applying the New York Stein-Hilber factors, are the challenge statements fact or opinion within the meaning of New York defamation law and the New York State Constitution. With that preview of the court's particular concerns, counsel, you may proceed. Ransom says, thank you very much, Your Honor, and thank you for the guidance, which is helpful. I will focus my comments on Drake's defamation claim, although I would like to address the other two claims as well. And I'll focus on our primary argument, which is also the subject of the court's questions, which is that the statements at issue constitute non-actionable opinion rather than statements of fact. And to frame it, including in light of the court's questions, I want to start with a critical observation, which is that under binding New York law, that issue, the fact versus opinion issue, is a question of law solely for the court. It is solely for the court to decide as an issue of law, which we believe makes it particularly suitable for a determination on a motion to dismiss. And we see, and I will address, a number of cases dismissing claims on this basis. Of course, UMG wants this to be knocked out as quick as possible and to not have to go to trial. And it is amazing to me that not once in Drake's 27-page brief does Drake acknowledge that this is in fact an issue of law for the court rather than a factual issue to be determined by a jury. Judge says, well, let me stop you there, because you are correct that there are a number of cases where courts have decided this on a motion to dismiss. The New York Court of Appeals in Bryan is one such case. But then, subsequently following Bryan, New York Court of Appeals and Davis v. Boheme, which was in the context of a motion to dismiss and relied quite heavily on the early procedural posture of that case in finding or holding that the standard that applied at a motion to dismiss stage was whether or not the communications taken in their ordinary meaning and context are susceptible to a defamatory connotation, and suggested that if they were, and that if they could be taken in such a light, then the motion to dismiss should not be granted and discovery should proceed, which strikes me as being somewhat in tension with the court's prior decision in Bryan, which, as you have observed in your brief, did permit a motion to dismiss because it is an objective standard. It's a reasonable listener standard, a question of law, and applied a somewhat different articulation of the test as to would the reasonable listener have understood the allegedly defamatory comment as opinion versus fact. All right. Now, when they talk about reasonable listener, they're trying to basically say the average listener in so many ways, right? Does the average listener understand not like us to be opinion versus fact? And Roland Ransom from representing UMG is going to argue that this is all opinion. However, it is also being backed by, well, not backed necessarily, but also the fact that there are multiple rumors out there around Drake and the nature of PDF claims to say that Kendrick at least had, at bare minimum, additional context from public record rather than having some exclusive knowledge, as Drake has been trying to allude to in his complaint. All right, we'll continue. So I would like you to address that tension between those two cases. How do I reconcile them when I have to apply New York law? Ransom says, of course, Your Honor. Two things about Davis versus Boheme. The first, including the way the court characterized it, the issue of whether a particular statement is susceptible to a defamatory connotation is a distinct element of the defamation claim from the question of whether it is fact or opinion. And I recognize that on that issue. Whether a statement is susceptible to a defamatory connotation, there are cases that suggest that where there's a dispute as to whether statements could have a defamatory connotation or not, might go to the jury. That is treated distinctly from fact versus opinion, and in fact, We see that distinction in Goldfarb, the case that Drake primarily relies upon, and which, as we pointed out in our reply, they misapprehend on this point because the court considers separately and distinctly the question of defamatory connotation on the one hand and fact versus opinion on the other. And as to fact versus opinion, the court expressly notes that this is a pure question of law. The second observation, judge jumps in. That is true, but I do want to press back on your reading of Davis, because Davis also does consider the opinion versus fact distinction and says that they cannot state as a matter of law that the statements are pure opinion because there's a reasonable view of the claims that have been asserted in the complaint and that the court has to take that reasonable view in light of in favor of the plaintiff at the motion to dismiss stage and therefore decides not to dismiss it. So although, yes, they also discuss the defamatory context, there is a portion of that opinion that is focused on the opinion versus fact distinction, which is the one raised by the defendants in this motion. Ransom says, and I do think in that respect, there's a slight conflation even in Davis. That said, Davis continues to apply the Stein-Hilbert test, including the consideration of the four, sometimes collapsed as three elements of determining fact versus opinion. And I think what's ultimately critical about Davis gets to the court's final question of those that it laid out, which is this fact versus opinion? And what was critical in Davis was the court's ultimate conclusion that the nature of the statements in Davis strongly suggested that the speaker had undisclosed information underlying his statements that would lead a person to conclude that they were statements of fact. Okay? So remember, I just said a few minutes ago, Drake is trying to say that Kendrick has undisclosed information. Roland Ransom is saying, hey, he's leaning on that, but Kendrick Lamar had no such information in the creation of Not Like Us, and we're going to tell you why. And as you walk through the ultimate conclusion of Davis in determining that it survived a motion to dismiss on the fact versus opinion issue, it was ultimately driven, I submit, in its entirety by the court's conclusion that there were multiple factors that would lead a listener to believe that the speaker there had undisclosed information unique to him that led to him to make the statements that he did. That included his reference to the fact that there was an investigation at the university underlying his conclusion, that his statements came out before the results of that investigation were released, that he had held a position of authority at the university about which he could speak with authority and solemnity, and that the nature of his comments presented for an article and discourse on the issue were such that they were not rhetorical hyperbole. Rhetorical hyperbole, again, is what UMG is leaning on heavily. They were not in extremist or other consequences that lead one to conclude that they are likely to be statements of opinion. So that was the ultimate conclusion reached by the court, and we have none of that here. None of the context, none of the indicia that suggests a thoughtful statement of fact based upon some weighty investigation as to which the speaker is privileged. Meaning Kendrick did not have any undisclosed information, right? And I'll address that in greater detail, but I think it's critical, even under Davis, which continues to articulate and apply the Stein-Hilbert factors, to emphasize that context is key. In Stein-Hilbert, here are the words. Even apparent statements of fact may assume the characteristics of statements of opinion when made in a public debate, heated labor dispute, or circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. Stein-Hilbert was 40 years before its time. Epithets, fiery rhetoric, or hyperbole. It might as well have said statements in a rap battle, okay? So he's drawing parallels between these two things. The Stein-Hilbert case. And even Stein-Hilbert and the subsequent cases, including Davis, and as exemplified in Davis, recognize that the contextual assessment of the context in which the statements are made often ultimately determines whether one would perceive these as fact versus opinion. And that's what was found in Davis because of the context in which those statements were made. And on the other hand, in Stein-Hilbert, because of the context the statements were made in Stein-Hilbert, the court affirmed a motion to dismissing the complaint as a matter of law, concluding that although the statements may be perceived as factual, the context in which they were made would lead a reasonable observer to conclude that they were pure opinion, including because of the heated nature of the communication. All right? So he's saying, just like Stein-Hilbert, which was dismissed, We're talking about fiery rhetoric, rhetorical hyperbole, and basically a mudslinging match. Okay? Judge says, since you bring up context, isn't the logical import of your argument that statements made in either a rap battle or diss track, therefore, are categorically opinion? Isn't that the logical conclusion of what you are saying? And is that a fair reading of New York case law that where New York courts have said forum is not necessarily dispositive? But does it seem to me that you are arguing that forum here is dispositive? A rap diss track just can't be taken as fact. So the judge pushes back and says, okay, just because it's said in a rap diss track, does that mean I can't think that anything is true? Ransom says, Your Honor, the cases that say forum is not dispositive, I don't dispute that proposition as a general proposition. It's typically raised in the context, for example, of an op-ed page or a letter to the editor, where the context would tend to suggest one of opinion. But the courts say it's not dispositive. And I suppose in those circumstances that it's theoretically possible that the nature of the communication, even in what is otherwise thought to be an advocacy piece with heated rhetoric, may support a finding of fact versus opinion. Whether a diss track in a rap battle could ever cross the line from opinion into fact is an interesting question. I would submit that the nature of the art is that is, at most, highly unlikely, and may categorically be the case that it doesn't. But what we're dealing with are the facts in the case here, and what we can see and what we can look at on the facts here is that the nature of the lyrics clearly convey the sort of rhetorical hyperbole, over-the-top trash-talking extremists that, using the language of the Court of Appeal in New York and the federal courts applying it here in the Southern District of New York, are clear, and we submit dispositive indicia of rhetorical hyperbole and an opinion rather than fact. And you can see that more pointedly in cases that are closer to this than those that offer the reservation about the form in which the statement is made. So in Hobbs v. Imus, for example, again, affirming the grant of a motion to dismiss, the court relies on the fact that these are shock jocks. And it's not just the limited statement in which the alleged defamatory communications are made. The court relies upon their notorious history and the nature of shock jock journalism from these speakers in particular as supporting its conclusion on a motion to dismiss that the context tells you that these are statements of opinion. So now they're drawing parallels to shock jocks on the radio who say things just to get a reaction out of the audience. It's already understood that they're doing this with hyperbole, and the audience pretty much already knows what they're getting into when they hear it, right? And Ransom is basically saying that in the case of a rap battle, it's the same thing. It's understood that you're going to hear exaggeration and all types of other things. Okay? And it acknowledges that if you just look at the statements taken in isolation, one could argue that they have the indicia of fact, but when you look at the shock jock context, the court ultimately concludes the claim must be dismissed. Okay, he goes and brings up Rappaport. The judge interjects. Again, let me press you on this. The context here is the rap diss battle, and we're here on a motion to dismiss. When I'm considering that context, don't I need to know more about whether the ordinary listener of, and maybe there's a question as to who the ordinary listener, is it someone who doesn't follow rap music and is just hearing it on the radio? So then the judge pushes back and says, hey, taking the context of this rap battle, who is the audience? Right? Is it somebody that's locked in, dialed into rap music to know all of the in and outs of it? Or is an ordinary listener someone who doesn't follow rap music and just happen to hear the song and hear a catchy tune, and then they hear these insults being hurled at Drake? Judge is not making a statement. They're just simply asking a question for Roland to, evaluate, assess, and answer. Is it someone who's actually immersed in the community and that type of music and has that background, like us, those of us that are tuned in now? Those are questions that we could also discuss. But with respect to the context on a motion to dismiss, how can I say that the ordinary listener would, comparing this to the shock jocks say shocking things? How do I, sitting here as a judge, know that the ordinary listener of a rap diss track would also have that same underlying assumption? Isn't it true, for example, that sometimes accusations are made in rap battles that are true and turn out to be true? And maybe listeners have that understanding. And sitting here as a matter of law, can I say that they would not? Do I need to have more discovery, potentially experts, potentially more context for this particular rap battle or rap battles writ large before I can make such a judgment as a matter of law? So the judge is saying, once again, do I need more information? Is it actually ethical for me to make a determination at this stage without additional context? Ransom's job is to convince the judge that she can. Ransom says there's no suggestion in any of the cases that this is the subject of, for example, expert testimony or otherwise. What the court is required to do under the standard as articulated in both the New York state and federal cases is to look at the material before it and reach that determination based on its evaluation of the statements and the surrounding context. And we can again look to an example in Terrain v. Lou, in Terrain v. Lou, again, resolved on a motion to dismiss. The court did take into account the context, and I do want to address the court's question about whether it can look at this material at this stage, because I think Terrain is particularly probative of this point. But the court looks at the information and makes an assessment on its own. It did the same thing in Rappaport. Now, admittedly, Rappaport was a summary judgment motion, but it illustrates the nature of the information the court is to consider in reaching that determination, which is the language used and the broader context in which it is provided. That's the universe of the material it looks at, and then it comes to a judgment. The universe of the material, he says. Judge Vargas says, but if the broader context, which is what we're talking about, is perhaps a specialized world, then perhaps the court does need more information than is in the four corners of the complaint. And even in the request for judicial notice to understand that context and correctly apply the legal test. Do I have enough facts about the broader context to come to a decision about what a reasonable listener would conclude, whether or not the statements made in the song are to be taken as fact or opinion? So for anybody that's wondering why this case has not been, thrown out by the judge up to this point, dismissed, is because the judge is trying to understand what am I looking at here? Like with these rap diss records, how can I determine whether or not this is defamation? I have to look at the audience. How is the audience perceiving the music? And unfortunately, there is no universal answer for the audience. Everybody has an individual opinion, especially depending on what side you sit on as far as who you favor in the outcome of the battle. So there is no one answer, right? Which makes it tough, which makes it harder for Ransom to kind of prove that this is meritless, right? Because a judge has to treat these things with care. An average person, if something like this came across their desk, they'd be like, man, get the fuck out of here. The judge is like, I can't necessarily look at it from that way. I would love to, probably, but is there more to it? Ransom says, Your Honor, again, what the cases do is look strictly at the material that's presented, including the context that's provided. You do have additional information, certainly in the form of the amicus brief that was provided in support of our motion, but also from the complaint itself. So now Roland Ransom, that is saying, hey, if you need more context, just look at the amicus brief of all of these esteemed journalists and educators that came and spoke on behalf of rap battles. You have the context of what is to be expected from a rap battle, and we have Drake's complaint itself. And what is interesting and notable in this case is that the complaint not only includes the allegations, but it cites and references the fact of the rap battle, articles describing the rap battle, articles describing the context of the rap battle and the history between these particular artists, including the rumors, innuendo, and controversies that have surrounded Drake with respect to his relations with underage women for an extended period of time. The context is provided there. So now Roland Ransom says even in Drake's lawsuit, he makes reference to articles in his own exhibits showing the history and the documentation of publications looking at Drake in the context of having suspect relations with underage women. Perhaps not sexual, but questionable nonetheless. There's no suggestion in the case law that the court needs to limit itself to a particular type of individual, a particular type of listener, or that every listener has perfect knowledge of all the information surrounding it. That would turn an objective test into a subjective test that's dependent on individual particular listeners with very specific information, and none of these cases suggest that that is required. In fact, all of the cases, did I just fucking cut out? All right, we back, y'all. Sorry. This nigga was just really getting in his bag. In fact, all of the cases that talk about this issue posit that the information is generally available and considers with that information that is available what would the objective listener reasonably understand. And on the question of what the court may consider and evaluate, again, we loot at terrain in particular. Here's a case where the speaker made a statement and the plaintiff disputed whether or not the court could consider the surrounding context, including earlier statements by the plaintiff that prompted the defendant to make the challenged remarks. So now he's pointing out this terrain case where the plaintiff basically made a statement and the defendant said something back, which ended up being like the subject of a lawsuit. Similar to Drake, who challenged Kendrick to talk about the young girls. Kendrick then made reference to it. Then Drake decided to sue, right? Terrain, the plaintiff contends the district court improperly considered the statements that he made during his war of words because they were not included in his complaint. That's also what Drake did. He didn't use any of his lyrics. He didn't reference any of the songs that he released in the actual rap battle. He only honed in on Kendrick's. Roland Ransom says that argument fails. As noted above, in determining whether a statement is actionable, the court should look to the overall context in which the assertions were made and determine on that basis whether the reasonable listener would have believed that the challenged statements were conveying facts about the libeled plaintiff. Terrain himself introduced this context in his complaint, noting that he was engaged in a war of words with a rival disc jockey. That's exactly what we have here. Drake's complaint identifies the rap beef, identifies a number of the tracks in the rap beef, and then cites countless articles describing and discussing the rap beef and all of its context. And all of that is properly before the court and may properly be considered by the court in connection with a motion to dismiss. And I think what's critical is that it includes, for example, Drake's own statement in Tailor-Made Freestyle, in which he specifically said and prompted to Kendrick Lamar, referring to himself in the third person. Talk about him liking young girls, that's a gift from me. So when Kendrick Lamar then raps, "Hey Drake, I hear you like I'm young," there's no secret or surprise or mystery of the context in which that statement is made. Again, these lyrics, this context is all properly before the court, including because of the way the complaint is pled and the abundant references not only to the lyrics themselves and the beef itself, but also to articles that provide the context to the court that allows it to make the determination that it needs to make. Roland Ransom going to fuck in. I ain't gonna lie. I'd like to briefly address what seems to be the primary argument that was raised by Drake. Although I think not necessarily specifically raised by the court, but in the event there's a question, there is heavy reliance on online statements made after Not Like Us came out, which Drake says suggests that members of the public believed that there were statements of fact rather than opinion, and this argument is wrong for many reasons. It misstates the standard because, again, you don't look at the subjective view of individuals. It is an objective test based on the reasonable listener. So it doesn't matter what 10 or 20 or 40 or 60 people say, because that just reflects subjective views. And that's even before you get to the substance of the reviews, which themselves reflect this rhetorical hyperbole. So he says even in the comments that Drake is referencing in his complaint, they have rhetorical hyperbole, which is one of their defenses. Not to mention emojis and misspellings, profanity, and even racism and anti-Semitic remarks. So now Ransom is pointing out those comments from YouTube, Twitter, etc., that Drake is trying to use as his reason as to why he feels defamed, Roland Ransom is saying, hey, these these are not reliable testimonies. Nothing of that informs the objective standard the court is to apply. Second, it ignores the fact that this exact same argument was raised and rejected in Rappaport directly at the district court, where evidence was submitted of all of these statements and people after the diss track was released by Barstool challenging Rappaport, and Rappaport argued this shows that people thought it was fact. And the court rejected that argument, and the Second Circuit affirmed. And it ignores Drake's own statement. Drake's own statement, which we've attached as Exhibit A to the request for judicial notice, about the pernicious danger of relying on statements in rap tracks and rap lyrics as truth, as evidence of truth, as statements of fact about the chilling impact on this art form and the chilling impact on artists. And I don't think that can be overlooked. Drake himself took the position that you shouldn't do exactly what he's asking you to do right now. He was right then and he is wrong now. Finally, on defamation, Drake has also argued that this is somehow mixed opinion, suggesting that somehow Kendrick Lamar is uniquely and privately privy to undisclosed facts about Drake's sexual proclivities. Okay? So he's saying, hey, this is ridiculous. Drake is out here saying that Kendrick somehow knows what Drake likes to do in his bedroom. I think just to say it refutes it, but again, Drake himself goaded Kendrick with talk about him liking young girls, that's a gift from me. And Kendrick says, hey, I hear you like them young, and goes from there and not like us. No suggestion of some hidden secret information. But in any event, this is also an issue of law for the court. So now the judge jumps back in. But there are lyrics that tend to suggest, as plaintiff points out, that there is information that Mr. Lamar is privy to. The reference to the rabbit holes and other truths that he can tell, that one potentially could read as suggesting that either his statements regarding Drake are based on undisclosed information, or that potentially there are other secrets that he has not revealed. There's some ambiguity there, but on a motion to dismiss, I have to read the ambiguity potentially in favor of the plaintiff. So the judge says, hey, well, what about the lyrics where Kendrick says, rabbit hole goes deep, I could go further, I promise. What is it that he's alluding to? Is there more information that the public doesn't know about? What is he saying there? And based on the ambiguity of that statement, I have to consider it. Ransom responds. And again, the case law makes clear that that is also an issue of law for the court, and that the court is to consider context in that specific circumstance as well. We see that in Cooper v. Templeton and in Steinhilber itself, where the court says, in evaluating this question of whether there are undisclosed facts, the court must consider the context. And so, for example, in Woodbridge, the court says, although some of the statements are based on undisclosed, unfavorable facts known to the writer, the disgruntled tone and anonymous posting, among other things, point to opinion, and ultimately concludes opinion rather than fact. We also see the same thing in Terrain, which, although it suggested some unknown fact, the court said, look, I look at the context as a whole, and this heated public statement tells me that notwithstanding this trash talking, including about putative undisclosed facts, ultimately is one of opinion. So yes, when Kendrick refers to a rabbit hole, that is part of the rhetorical hyperbole throughout Not Like Us, and the court must consider that context in evaluating that as well. So again, Roland Ransom refers to rhetorical hyperbole as it pertains to the rabbit hole, saying he's just exaggerating. He's painting a scene, but it's folklore. It's the same way when Drake threatens that Kendrick's darkest secrets are coming to light. Ah, nice one. Nice flip there. So then he points out where Drake said on Family Matters, your darkest secrets are coming to light. Or that Drake dug up bones in an excavation on The Heart Part 6. That context is part of the nature of the rap battle. And we see that in the amicus brief as well. It does not save Drake's claim here. Judge comes back. Let me challenge you on one specific lyric from Not Like Us. And that's the Certified Lover Boy Certified PDF. It does suggest particularly the use of the word certified. Again, an ambiguous term, but paired as it is with certified PDF. It could give the listener, a reasonable listener, the impression that in some way there's been some determination that in some unspecified official way that Drake is a PDF. What is your response to that argument? Ransom says, so two things about that. First is, I think it's critical in considering that particular passage to pair it to what precedes it, which the court quoted, certified lover boy, certified PDFs, referring to Drake and his crew. The certified lover boy is the name of a Drake album. And so it is clearly and deliberately a play on those words. And any more than the certifications of Loverboy status has meaning, the reference to certified PDF is more of the rhetorical hyperbole that we see in the precise context. It also can't, now the judge jumps back in, but that was a nice one. He says it was in the plural, referring to Drake and crew, not just Drake. Or not Drake in particular. Judge says, this does bring me back a little bit to my prior question, though, which is, who is the ordinary listener? Who are the people hearing this and receiving it? And what is their perception when they hear it, right? Is it someone who's going to catch all of those references and all of those nuances between these two artists and the community writ large so that they're going to understand that Drake had a prior album called Certified Lover Boy and this is a play on the words? Or is it the ordinary listener who may not listen to either one of these artists with any regularity and may not have that familiarity? Who is the ordinary listener and how do I apply that test when there's so much specialized and nuance to a lot of these lyrics that does require in-depth analysis to catch all of those references? So the judge is saying, well, what about all of these references made in the lyrics? How am I to expect everyone that heard this song to know Drake has an album called Certified Lover Boy and that it's a play on those words rather than outright calling him a PDF? Ransom comes back. So two things, Your Honor. One, on that question, all of the cases, at least in the way they apply to the law, consider the entirety of the context. They don't slice and dice it down to what a particular, goddamn, homie, of all the context may know and whether every listener knows every piece. In every one of these cases, what the court looks at is the context as a whole, not sliced and diced down to individual listeners or assuming that it's limited to people who just actually have specific knowledge of particular pieces of this. The other comment I would make with respect to the concerns regarding nuance, or will someone get that, is that there is a danger to that approach that is at least warned in Brian v. Richardson and also in Mann v. Abel, another New York Court of Appeal case, about sifting through communications and picking particular words or phrases out and considering them in isolation. All right. So he says taking words out in isolation is problematic. And he's going to give context as to why. And what Brian v. Richardson says is that it's dangerous to do because rather than sifting through a communication for the purpose of isolating and identifying assertions of fact, the court should look into the overall context in which the assertions were made and determine on that basis whether the reasonable reader would have believed that the speaker was conveying statements of fact. We see the same thing in Mann v. Abel, another New York Court of Appeal case. Although one could sift through the article and argue that false factual assertions were made by the author, viewing the content of the article as a whole as we must, it was protected opinion. And in that case, also the claim was rejected. So he's pointing out more cases in which opinion was found rather than fact, and then it was dismissed. So the notion of trying to look at a particular phrase, tease it out, and not take into account the broader context of Not Like Us as a whole, hey Drake, I hear you like I'm young, and Drake's statement, talk about him liking young girls, and then the broader context of all the rumors and innuendos and controversy surrounding Drake, young women and girls, I believe, misses the thrust of the case that drives the court's decision, particularly Brian and Mann. So Roland Ransom is basically saying the things that we've been saying all year. Like, yo, this is a rap battle. There's a back and forth exchange here. Drake is just trying to, cherry pick statements out of the lyrics and make it seem like Kendrick is picking on him and defaming him to the world, where these guys were hurling insults at each other, and this guy literally told him, hey, talk about this. That's a gift from me. And he did. Judge comes back. This brings me to my second question, which is the question for judicial notice, because the rumors, innuendo, etc., are not set forth in the four corners of the complaint, except perhaps in some of the exchanges in the song lyrics. But obviously, the defendants have submitted articles that it wants the court to take judicial notice of that allude to those rumors, and presumably, for the purpose under Rule 201, it's not necessarily for the truth of those rumors, but that those rumors existed and were present in the world. All right. So the judge is acknowledging all of the clippings that UMG has included to show that there has been conversation surrounding questionable activity from Drake. And it's not about whether or not those rumors were true. It's just the fact that those rumors pre-existed, not like us, massively. Ransom says that is correct. It is not for the truth of the rumors, it is for the fact of their existence and the context that it provides with respect to the statements and not like us. But as to whether the court can take judicial notice, the answer is in that respect, certainly. News articles, well within the scope of judicial notice, are as song lyrics. And that is particularly true here because of the articles that we are citing and referencing come from Drake's complaint. So he's saying the very articles that we're putting in here, he cited them as well. They are referenced in, cited in, and some of them discussed in Drake's complaint. Now, not necessarily the rumors portion, but the specific articles themselves are from Drake's complaint, and we cite them just as Drake did, and in our brief, we identify, in our request for judicial notice, we identify where from the complaint they arise. So this is not a scenario where we are going out and finding third-party material that has not already been brought into this case by Drake in his own pleading. On the contrary, when it comes to the question of rumors and the facts giving rise to the statements that are at issue here, those are included in articles that Drake himself cites and relies upon in his complaint. So we believe the court could properly take into account news articles under the standard RJN request for judicial notice standard, but particularly in this case where they are referenced in the complaint and cited in the complaint and relied upon by Drake. We think it's particularly appropriate, and the court is well within its authority to do so, and given the requirement that the court consider context, we think respectfully that the court is obligated to do so because that context has actually been provided, not just by us, but by Drake in his own complaint. So again, Roland Ransom is pointing out the deficiencies in Drake's claim because he actually referenced these very same articles that UMG says, okay, well, he's referencing them. Now let's look at the whole thing. Judge says, you said you also wanted to address the other causes of action. Let me give you a few minutes in which to do so. Ransom says, thank you, Your Honor. I'll be brief. We've obviously briefed our challenges, and there are many to both the Section 349 claim and the Penal Code claim. On the 349 claim, we believe that both parties' cases reflect that the information and belief form of pleading that Drake is using is improper, and that's a sufficient basis alone. But I think what's been made clear from the briefing is where that claim also and clearly fails is on the injury element. The New York Court of Appeal has clearly held that standing under 349 requires a direct rather than derivative injury. You can't have the series of steps between the alleged consumer deception and the claimed harm to Drake, and that's exactly what we have here. So many steps between the alleged consumer deception through artificially increasing the number of streams and any impact on Drake under City of New York v. Smoke Spirits in the Court of Appeal, the New York Court of Appeal, and Frentzilas in the Second Circuit. That claim clearly fails. On the Penal Code claim, we have multiple arguments, but I think the easiest and first argument is there's simply no private right of action. All of the cases that Drake cites don't grapple with the Sheehy standard from the New York Court of Appeal, which is then re-articulated in Ortiz. And the existence of criminal enforcement mechanisms for that claim really eliminate the prospect of a private right of action. The cases we cite acknowledge the binding Sheehy-Ortiz standard. The cases that Drake cites largely don't, and in fact are based on authority that predates that binding New York Court of Appeals authority. So we think both the 349 and Penal Code claim should be dismissed as well. Judge says thank you. Ransom says thank you. I'll give you an opportunity to argue in rebuttal at the end. Let me hear now from plaintiff's counsel. All right. Now, of course, plaintiff is Drake. So this is going to be Drake's lawyer now having a conversation with the judge to argue why the complaint should stand and move forward. Mr. Gottlieb, yes, Your Honor. Excuse me. Mr. Gottlieb, blah, blah, blah. Yeah, yes, Your Honor. Your Honor, I'd like to start, if I could, with the discussion about the appropriate standard of review because I think it cuts all across UMG's arguments in this case, and it is important to have a reminder both from the federal standard and the state standard of why we're here today. Under binding Second Circuit authority, the global network communications case that we cite in our papers, a complaint may not be dismissed pursuant to Rule 12b-6 unless it appears beyond doubt, even when the complaint is liberally construed, that the plaintiff can prove no set of facts in support of his claims which would entitle him to relief. Davis v. Boehm is the only opinion doctrine case cited by either of the parties in this case that remotely touches on the appropriate standard of review at the pleading context for evaluating an opinion defense, and it is utterly devastating to UMG's entire argument in this case. As we explain on pages 1 and 7 of our brief, the question on a Rule 12 motion when considering an opinion doctrine defense is not what this court thinks or what Mr. Ransom thinks a reasonable listener should have concluded when it heard the lyrics in question. The question is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff, all right? So here, Drake's lawyer is saying, hey, it's not about whether or not people concluded this. It's about the possibility, which I think makes things even more ambiguous. But that ambiguity favors Drake, unfortunately, at least in their argument. Davis v. Boehm is the controlling authority. There's no other case that either party cited that even purports to interpret the standard at the pleading stage. At page 268 of the opinion, the Davis court explained that at the pleading stage, we limit our inquiry to the legal sufficiency of plaintiff's claim without evaluating the sufficiency of the party's evidence, as would happen at the summary judgment phase. Davis expressly argued in this case that the court should reject the plaintiff's interpretation that were contained in the allegations in the complaint and instead hold, using the objective standard, which we don't dispute applies, that the reasonable reader would be likely to interpret this statement as pure opinion. The court rejects that, and this is the most important part of the opinion. The court says, on a motion to dismiss, we consider whether any reading of the complaint supports the defamation claim. Any reading? What? Thus, although it may well be that the challenge statements are subject to defendant's interpretation, the motion to dismiss must be denied if the communication at issue, taking the words in the ordinary meaning and context, is also susceptible to a defamatory connotation. Meaning, if it's susceptible to a connotation that it's fact and is susceptible to a connotation that it's opinion, the plaintiff wins at the motion to dismiss stage. So he's basically trying to say if anybody in the world could perhaps come to the conclusion that these are true statements about Drake, then we need to move forward. This can't be dismissed. That's Drake's lawyer. Now the judge comes back and says, as I asked Mr. Ransom earlier though, how do I square that with other Court of Appeals decisions, including Bryan, which was also a motion to dismiss decision in which they do not purport to overrule, so therefore remains good law, still cited by New York courts, but did not use this could standard. Did not say it's susceptible to a defamatory connotation, but says instead, the question is whether or not it would be understood by a listener as opinion or fact and presents it as a question of law. So the judge says, hey, in these other Court of Appeals decisions, they didn't use such language as could or is susceptible. Okay? Judge says that's not the type of language we use around these parts. Gottlieb comes back. So, Your Honor, judge cuts him off. You see it here. I take you that Davis definitively throws a wrench in the argument, but there seems to be some tension. How do I reconcile that tension? Look at the way that the judge is talking to Gottlieb versus the way the judge was positioning their questions to Ransom. That's all I can say. Your perception may be different from mine. Mr. Gottlieb says, so, Your Honor, I don't think there's tension. So first of all, Davis is the subsequent and most recent opinion, so it'll be controlling for this purpose. The Bryan court doesn't purport to interpret the pleading standard. So there was no dispute between the parties as to what the court's inquiry ought to be in evaluating the pleadings is one point. The second is there's no discussion or suggestion in the Bryan opinion anywhere that there was a challenge to the actual content of the allegations in the complaint, which is what we had in Davis, and it is what we have here, where you have the defendants essentially saying, don't credit or believe or draw inferences from the allegations in the complaint in the plaintiff's favor. Instead, accept this other evidence that we're presenting to you and draw inferences in order to determine what the appropriate social context is so you can make your decision as a matter of law. I think that's what you're asking too. You want the social context, but you don't want it to be favorable. So you say, hey, whatever people could think, draw that conclusion. He continues though. He says, in Bryan, the only thing that the court considers, at least from what one can tell from reading the opinion, is the four corners of the op-ed that was being considered. The court was merely analyzing an op-ed and talking generally about what op-eds are. There's no suggestion in Bryan that there was an attempt to insert extrinsic evidence into the record. There's no suggestion that there was any challenge to the inferences that the plaintiff was being asked to draw of the complaint, and the Bryan court makes clear that in the text of the article itself, the author made clear that the purpose of the article was to advocate for an independent investigation, and in support of the argument, the defendant marshaled all of the relevant materials included within the text of the article. So the court had basically everything it needed in order to analyze both whether it was capable of a defamatory meaning, whether it can be proven true or false, and what the context immediately of the article and the broader social context were. There simply is no indication that there was any dispute before the court as to any of that. Basically saying you should only be looking at what Drake has to say in his complaint, not what UMG has submitted for additional context. In this case, what we have, by contrast, is an express request for judicial notice that I want to address before I get into the sufficiency of our allegations, if I could. That request for judicial notice asked the court to accept 17 exhibits into the record and to use evidence contained in the exhibits to draw inferences that directly attack, contradict, or undermine the allegations in Drake's complaint. Now, there is a time and a place for the weighing of evidence, but that is either at trial or the Rule 56 stage. It is not here. And UMG has no answer whatsoever to the binding Second Circuit authority that we cite at page 14 of our brief, which is the Global Network Communications case, in which the Second Circuit makes clear that the conversion requirement of Rule 12b is mandatory, not discretionary. And under that rule, once again, the judge cuts the fuck in. Rule 201 allows me to take judicial notice at any stage of the proceedings. She comes in and corrects them mid-sentence. She said, Rule 201 allowed me to do this shit whenever I please. That's explicit in the rule. And certainly, ample cases take judicial notice in the context of a motion to dismiss. That doesn't convert it to a summary judgment motion. By definition, it doesn't, because I am permitted to consider both materials within the four corners of the complaint, matters that are incorporated by reference or that are integral to the complaint, and facts that are judicially noticed through Rule 201. And if I do, then that doesn't convert it to a summary judgment motion. So the judge jumped in and corrected his ass swiftly. Gottlieb comes back. That's correct, Your Honor. We don't dispute that. What we dispute is UMG's suggestion that the court can either use the materials for either the truth of the matter asserted, which they're disclaiming here, but also can use the materials to make factual inferences based on the content of what the court finds within those exhibits. Judge comes back. Well, let's just talk about the song lyrics in the rap battle. There's an argument that they're already incorporated by reference, except perhaps one, the tailor-made freestyle, which is notably omitted in the amended complaint by reference. But the other songs in the rap battle are referenced and linked to their Spotify, or I think it was their Spotify listing. So I'm not even sure that I need to take judicial reference that they're not incorporated by reference into the complaint, but certainly there can't be dispute about what the lyrics are. The lyrics are what they are. I'm going to put a pin in this. Look at what the fuck the judge just said. Judge said, tailor-made freestyle was notably omitted from the amended complaint, which is where Drake originates the idea of him speaking to young girls. You guys conveniently left that out. So let's look at the rap lyrics for what they are. This is the judge. This ain't J Nolan. I would hate to be a fucking judge. Gottlieb says, so to make this easy, we don't challenge that the court can take notice of the fact that lyrics exist in a song out in the world. The question is how one interprets those lyrics and what meaning is given to those lyrics in the context of evaluating the rap battle. Similarly, of course, we don't challenge that there was a rap battle. We plead that in our complaint. What we take issue with is UMG using lyrics to draw inferences about what reasonable listeners and reasonable viewers would have understood about the song in question. That is where the argument strays from what is permissible under the court's judicial notice authority, and it also strays, once again, he gets cut the fuck off. Judge says, once the lyrics are in evidence, then of course I can draw inferences from them. So she corrects him again and says, hey, y'all wanted to introduce lyrics? Lyrics have been submitted, so now I can draw inference to them. I can take them all into consideration. They're in evidence. They've been judicially noticed. The lyrics exist. They have the meaning that they have. They're words. And I don't understand your argument that I could take judicial notice of a song lyric, but I'm not allowed to consider what the lyric means or says. You basically saying that the judge shouldn't even think. Gottlieb says, because at the pleading stage, the court is not allowed to make inference against the plaintiff. So he says, at this stage, everything submitted is supposed to be in favor of the plaintiff. The court is required to draw all reasonable factual inferences in plaintiff's favor, and the court's not allowed to take materials from outside of the complaint and use it to discredit or undermine or question the allegations that have been plausibly alleged in the complaint. And I think this argument around context this is an important example. So, for example, we have alleged throughout the complaint what the appropriate context for the understanding of the lyrics, the cover art, the video, and the song are. So he's saying, we already told you what this stuff means. Why are you doing additional thinking? We have alleged that the full context includes the lyrics of the song, the cover, the art, the video, and have explained in numerous allegations throughout why a reasonable listener or reader or observer would have interpreted those songs as conveying a singular and precise factual message that Drake and false message that Drake is a PDF. Judge comes back. But isn't that a legal argument that I don't have to draw an inference in your favor? Because whether a reasonable listener would have drawn that inference is a question of law, which you've already agreed is a question of law, and legal assertions or arguments made in a pleading do not have to be credited by the court. Gottlieb comes back. This is Drake's lawyer again. For anybody that joined us later, Gottlieb is representing Drake. The question, though, is not what a reasonable listener would have interpreted the lyrics to mean. The question is whether a reasonable listener could have interpreted the lyrics to mean. In other words, is it reasonably susceptible to a defamatory connotation? He brings that back up, even though the judge questioned him about that before. That's the Davis standard, and we think we have more than adequately alleged that. But more to the point, we have specific factual allegations in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. This is Drake's lawyer here. He's saying UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. Now, we may have joked and acted as though Not Like Us is the national anthem, but let's be fucking clear here. That song is not the national anthem of the fucking United States. It was popular during its time, and it's still somewhat popular, but it's not a national anthem, homie. That's alleged at paragraphs 10 and 11 and 128 through 202 of our complaint. The complaint alleges facts showing that UMG wanted to and succeeded in making the song culturally ubiquitous. And this means that the audience, to answer one of the court's questions to my friend, the audience by which to evaluate defamatory meaning in this case is not the people who would be dialed in to every back and forth between Kendrick Lamar and Drake in the rap battle, but the audience is everyone exposed to the lyrics and imagery, not just those sort of there in the moment. We cite the Lindell v. Mail Media case in the Second Circuit that stands for that proposition. So they say this is not about rap fans. This is about the fact that this song became so big. This is particularly important because we also allege with specific numbers that this song achieved a cultural ubiquity unlike any other hip-hop song in history. Not just unlike the other songs in the rap battle, but unlike any other song in history. More than 9 billion streams at the time of the filing of our last brief have been 9 billion times have been streamed on this song, which Drake is still flabbergasted that Kendrick could ever do such a thing, right? Every other track in this rap battle pales in comparison to that. So the relevant audience member, if the court is trying to understand the objective listener, objective viewer, cannot be the person who listened to every single track in the rap battle. The relevant person is probably your average 13-year-old who's alleged to be dancing to the song at a bar mitzvah. What? You're saying that the supposed audience of Not Like Us are 13-year-olds at bar mitzvahs? So it's only 13-year-old Jewish kids. What about the fact that America is one of the most culturally diverse nations in the world? You hone in on 13-year-old Jewish kids? Okay. Who may not have heard any of these other songs before or may not even be that much of a rap fan. Judge says that would be a very interesting bar mitzvah that played that song. Gottlieb says that is apparently very popular at bar mitzvahs, Your Honor. Judge says I'll take your word for it. Gottlieb says there's a separate set of factual allegations in the complaint that add to this that UMG also doesn't add, and that's contained at paragraphs 90 through 92 of the complaint. We allege that in sort of the modern social media environment, allegations of PDF activity are of the far more relevant social context than whatever might have been true when Judge Daniels with considering these issues in terrain today, given the massive global audience for this song, that it reached the entire world and the social media environment in which allegations of PDF land. Today, audiences are simultaneously primed to believe and primed to react with outrage to allegations of harming children. And that is a direct response to many of the generalizations contained in the cases that UMG cites and many of the arguments they're making. There are specific allegations at paragraphs 90 to 92 of our complaint. UMG is asking you, based on their sort of own spin of exhibits, to disregard these well-pleaded factual allegations in the complaint about how sort of the world today receives these type of allegations, and we just don't think that can possibly be appropriate at the motion to dismiss stage. So they're saying because social media is so relevant today, the way people receive allegations of PDF activity, we can't just look at this through the scope of rap battles or back and forth. This song is too big, it's too popular, and too many people have engaged with it and heard these lyrics. You can't dismiss it at this stage. Judge says, let me go back, because we were addressing the various inferences that can be drawn from the lyrics. Remember, the judge said, let's focus on the lyrics. And one question I have for you is, do I have to draw an inference from the lyrics? Don't they speak plainly? So for example, let's go back to the Taylor freestyle. So the judge says, hold on, you keep talking around. Let's get back to tailor-made freestyle, please. You didn't answer nothing about that. Which is, talk about them like in Young Girls, that's a gift from me. And in the context with the AI voice of Tupac, it's clearly, one can clearly read it to be a goad from Drake to Kendrick as part of their back and forth in the rap battle, to bring up rumors regarding pedophilia and Drake. I don't know how else one could logically read that. If you have an alternate reading, I'd like to hear it, but I don't think I have to draw an extreme inference to understand what that line is. Judge said, hold on, homie. Let's go back to Taylor Made when he said that. He introduced it. What other meaning am I to derive from the words out of Drake's mouth? Please tell me if you have one. Gottlieb says, well, Your Honor, she cuts his ass off again. What would be the inference that would be favorable to plaintiff of that line, other than the one that I've just put forward? She backing this nigga down. He says, because, Your Honor, you would have to consider, as Mr. Ransom says, black letter law and opinion doctrine. You don't slice out a single line or a single statement from a song in order to ascertain its meaning. You consider the entire song and the entire lyrics in context. Judge comes back and says, but I'm asking you about this line in this song. How would I read it? You said I can't draw inferences from these song lyrics. I can just consider their existence. But do I have to draw an inference? He says, yes, you. She comes back, cut him off again. The words are the words. Talk about them like in young girls. How else would I read that? Pan-seared. Gottlieb comes back. Your Honor, I don't understand what legal relevance that has to the question of how a reasonable audience member would have understood the lyrics and Not Like Us. Before you even get to talking about the lyrics in his prior song, you would have to come to the conclusion that your average listener to Not Like Us came into the song with that lyric in mind, had heard that song, had been exposed to it, had understood the lyrics in the same way that Your Honor is reading them. And there's simply no basis on which to make that determination at the pleading stage in this case. They may come forward with evidence. Judge comes back in. Let me pause you there. I understand that a lot of these cases arise in a very traditional context of a newspaper article or an op-ed or a single communication. But here, we have songs that are in communication with each other, a dialogue with one another. One artist releases a song, a few hours later, another song is released that responds to that song and back and forth. That is the context in which those lyrics arise. So to take Not Like Us as the specific example and just to isolate it, isn't that taking it out of the broader context in which it existed? It would almost be like taking a single paragraph out of an op-ed and not looking at the headlines and the remainder of the article. But you can't look at Not Like Us in isolation. It's a response to what's come before. This is the judge telling him. We cannot take Not Like Us on its own. We have to look at the entire context in which this song plays a role. Gottlieb is reeling. He says, so Your Honor, we're not advocating for the court to not consider the context that this song was the penultimate track in the rap battle. That's not our argument. Our argument is this song in particular, both in the rap battle and in the history of music, is different. It is different in ubiquity it achieved. So its audience was different. It was different in the fact that it was immediately understood in the allegations of our complaint to contain a precise factual allegation and a single factual allegation, the false allegation that Drake is a PDF. We are let cut off again. At the time Kendrick Lamar released this song, there was no ubiquity. And there was obviously, he's not a fortune teller. Ooh! He wasn't going to understand that at the moment that he released this song, it was going to have 8-9 billion streams. And he would be singing it at the Super Bowl. God damn! Come on, Vargas. She said, how the fuck would he know he was going to get 8-9 billion streams off this song? He was releasing it as a part of the back and forth that occurred over the matter of days. And isn't that the context in which I need to understand the assertions made, not 6 months later that millions and billions of people have now listened to it and may not have that understanding. But at the time the statement was made, it was in direct response. And let me give you a hypothetical. If two people are arguing on the street and throwing insults back and forth, and then later one of them says, okay, that particular statement was slander, you've defamed me. I'd have to know what the interchange between those two individuals were that were throwing insults to understand the full context in which whatever statement was made. Isn't that comparable here? Someone insults, the other person responds with further insults, the other person responds with other insults. How can I just take one of these songs in isolation and apply a completely different standard to it because 3 months later, billions of people have now listened to it? Deep fried your ass. Gottlieb says, Your Honor, I appreciate the question. I think it stems from a lack of grappling with the, and perhaps due to imprecise briefing on our part, the nature, the role that republication plays in this case. We have alleged in our complaint, I believe in 11 separate paragraphs in the amended complaint, that UMG was responsible for republication of the defamatory material. That's paragraphs 13, 21, 120, 121, 157, 191, 192, 232, 241, 246, and 266. The standard for republication is that a defamatory statement is republished whenever it is intended to and actually reaches a new audience. That's the New York Court of Appeals decision in Firth v. State. Okay, and republished would be when it's performed at the pop out, when it's released as a music video, when it's performed on tour, when it's performed at the Super Bowl, when it's performed at the Grammys or played at the Grammys, or he wins a Grammy award for the Grammy. That's what they mean by republications, because each time that it goes in front of a new audience, it reaches a new audience. That's what they're trying to say. The judge just said, how would he have known any of that was going to come at a later time when he was just responding in a heated exchange? They say we allege this throughout our complaint. UMG said nothing about it until their reply brief in this case. So we have alleged that UMG took steps at multiple times post-May to republish the material and introduce it to new audiences, and each time it did that, it was liable for that republication. And each time it did that, its knowledge at that point in time becomes relevant. And we've pleaded that knowledge in the complaint, including what it knew in July, what it knew in August, based on retraction demand letters that we sent to it, what we knew when it was launched, the Grammys campaign, what it knew when it was launched, the Super Bowl campaign. But even if you don't agree with us on that, we allege in the complaint, before you get to republication, that the defamatory material includes the song, the cover art, both of which were released on May 4th, and the video was not released until July, 2 months after the release of the song. And UMG's knowledge at the time that it released the video included all of the information that we have alleged in the complaint, including the attacks on Drake's home in Toronto. 3 separate attacks on his home in Toronto, the attack on his OVO business in London, the fact that users all over the United States were commenting on him being a PDF, and the fact that Drake had denied factually the allegations in the Heart Part 6. So that goes to show he was already on the line with his lawyer about how he wanted to approach the Heart Part 6, which is why that song sounded so flat. We make all of those allegations in the complaint about UMG's knowledge at the time of the publication of the video, so that's the latest point. That's the earliest or latest, but their knowledge clearly at the July point in time, before you even start talking about liability for republication, comes into play. And then, Your Honor, with respect to your question before about sort of removing the song from the factual context of the battle, and it doesn't sort of have to be understood that way, we have alleged that this song was actually understood as a sort of singular entity because of its cultural ubiquity. And even the exhibits that UMG has put into its request for judicial notice, they prove this. So they're saying, we're not looking at this song in the context of a rap battle. It is a singular entity because it's gotten so big that it supersedes all of the rest of the interaction and engagement between Drake and Kendrick. We need to focus exclusively on this song. So, for example, UMG has Exhibit P, which is a podcast transcript that we cite a piece of in the amended complaint. At page 4 of that podcast transcript, there is a discussion about how Kendrick is making allegations about Drake. Some of these things have been fact-checked. And then later on down, one of the commentators says, I don't know if there's ever been a time when a rap superstar or two rap superstars are contemporaries and one is accusing the other of PDF activity, like in the loudest possible way. It continues. Contemporaries, people who are making their record label billions of dollars, right? That doesn't usually happen. And this level of allegation, maybe it should inspire some sort of investigation. That's a quote from a podcast. Later, on page 5, it says that one of the commentators says it's unclear right now if the claims of Kendrick Lamar's domestic abuse are true, but let's talk more about these allegations around Drake. No one has previously called out Drake in this way. Now it's being raised to a more mainstream conversation because it's a hit that Kendrick is making. Okay, so they're citing conversation from a podcast who clearly did not know about previous allegations made around Drake. So they said that this has never happened. The clippings in the dockets say otherwise. Your Honor, Exhibit B to UMG's request for judicial notice, page 10, the commentators described Lamar in this song as indicting Drake for years of rumors and speculation. Indicting, meaning a specific factual charge. So you're saying that Kendrick can indict him in a record? He has the power to indict somebody? What? Ain't you a lawyer? Indicting, meaning a specific factual charge being made in a song based on rumors and speculation. Notably, Not Like Us doesn't include the rumors and speculation in it. It doesn't talk about any of the underlying rumors that Mr. Ransom was talking about that Drake allegedly had to deal with in his past. It only includes the indictment, the specific charge that he is a certified PDF, the cover art, which is his actual Toronto home, which, by the way, is also validated by the other exhibit that UMG wants you to take notice of, Exhibit J. Page 4 describes the content of the song as sex offense allegation. Throughout Not Like Us, Kendrick accuses Drake of having inappropriate relationships with minors. This is also a topic Drake has had to debunk in the past. However, Kendrick doesn't shy away from blowing up the rumors surrounding Drake's personal life with his lyrics. I think it's very interesting that you cite a topic Drake had to debunk in the past, because you're also trying to make it seem like nobody had ever said this about Drake before. Your own references are contradicting each other, but that's just my opinion. Later down, the Predator accusations include the cover art for the track. In fact, an aerial picture of Drake's mansion allegedly dotted with SO location tags. These are the exhibits from commentators interpreting the lyrics of the song contemporaneously, understanding it with a precise meaning that it can be fact-checked, that can be proven true or false. So if these things are in the record, we're fine with it because they all prove that there is a susceptible connotation that can be drawn that the song had a precise meaning. Your Honor, I don't know if the court... Judge cuts him off again. Let me ask you this, though. Your client also, in the course of this rap battle, leveled accusations against Mr. Lamar as well. This the same stuff we've been talking about for a year. The judge brought it to the floor. Your client also, in the course of this rap battle, leveled accusations against Mr. Lamar as well. That he's not the biological father of his child. That he beats his girlfriend. Are those facts or opinion? So that brings us back to yesterday and the day before, right? Where Drake and his legal team are asking for facts of paternity, right? For facts of, let's see, his criminal history, any history of domestic violence. Because the judge specifically said, hold on, homie. You out here asking for damages because your boy was called a PDF, but what about the things that Drake said about him? Are those facts or opinion? Gottlieb says, are those, I'm sorry, Your Honor? He's flustered. He don't even know how to answer. Judge says again, are they fact or opinion, those lyrics? Gottlieb says, I don't know that the court has a record sufficient to be able to make the determination because the court doesn't have the context behind all the different allegations in the song. There isn't a complaint with 250 allegations giving meaning to the lyrics. So basically they're saying, hey, Kendrick didn't sue. Why are we talking about that? Kendrick has received no harm from this. He hasn't filed a complaint. We did. We don't know. Was there cover art? We don't know. Was there a video? Yes, there was a video. Stupid motherfucker. It's called Family Matters on YouTube. We don't know. Was there a singular message? We don't know how people understood it. Boy, you paying these fucking idiots. So that is both a determination that the court doesn't need to make here. This is Drake's lawyer continued. Nor is there one that the court has a record to make here. That could be the subject of questions that I imagine UMG will want to get into discovery in this case, but it is certainly not a reason to find that the pleadings fail to state a claim on which relief can be granted. I don't know if the court wants me to address the actual malice arguments that have been made. Judge says, I do not need to hear arguments on the actual malice. Gottlieb says, okay. Judge says, if you would like to briefly address the other two causes of action in the complaint, however, he says, sure. So with respect to Section 349 claim, Your Honor, Mr. Ransom made essentially two arguments. The first is he made an argument about information and belief pleading, and the second is about the injury element. So let me address the information and belief pleading. I think this argument just simply misunderstands the nature of the allegations that we make in the complaint, and so we don't think it actually matters whether the court concludes what the standard on information and belief pleading is. Excuse me. Even under the standard that UMG articulates, we believe our allegations meet that for purposes of Section 349. We essentially made four arguments that support the underpinning factual allegations of materiality and consumer harm under Section 349. The first argument we've made is that UMG misled streaming consumers by paying or by causing payments to be made to third parties to have bots artificially stream the recording on Spotify to boost streaming numbers, and that's paragraphs 173 to 178 of the amended complaint. Okay, so here we get back to bot talk from from Drake's lawyer. Now, UMG says that this is based on information and belief. But the standard here is plausibility under Iqbal and Twombly, and we more than meet the standard for following reasons. So under paragraph 174, we allege that fake streams are a huge problem in the music industry, and that UMG hasn't disputed that up to 10% of all music streams are false. And in 2021 alone, 1 to 3 billion fake streams across popular music platforms were fraudulent. If that's the only allegation we have, we agree we'd be in a bad place on information and belief pleading. But we continue that in paragraph 175. Fake and manipulated streams are significant problems for Spotify, which invests heavily in their reviews on it. So if they invest heavily on reviews for fake plays, why would they agree directly with UMG to bot a song? That's what y'all been alleging. But they're investing heavily in reviews on it. So you mean to tell me the money that they gain from UMG, they're going to just pay out to investigate further about it? I don't know. It is a reasonable inference that Spotify would not make heavy investments in a non-existing problem. We also allege that Not Like Us set records on numerous streaming platforms. It was the fastest song ever to reach 300 million Spotify streams in just 35 days, which is paragraph 130. And one possible inference of this, which we believe the court must draw at this stage, is that this unprecedented rocketing up the streaming chart that UMG was using a technique that is evidently used on 10% of all music streams to manipulate stream totals. So they say there's no possible way that all the people that played this song actually listened to it and liked it. It had to be fake. Now, UMG does not dispute any of the paragraphs from paragraphs 129 to 171 addressing its completely unusual and unprecedented tactics in promoting the popularity of Not Like Us. That includes things like whitelisting agreements with other parties. All of those allegations I just referenced are the background for the pleadings for the allegations that UMG describes as information and belief. That background supplies the context for paragraphs 176 to 178, which are based on three things. One, a popular podcast host who insists that he knew that Not Like Us used bots. That's Joe Budden, by the way. Joe Budden said he would love to come and be a part of this case and clown in court because he actually how would he know? How would he know that UMG botted Not Like Us? What What investigation has Joe Budden done? Come the fuck on, idiots. Second, are users on social media claiming to be music industry whistleblowers who witnessed the we we got social media niggas claiming that they got inside information on UMG. The buying of promotion through a digital marketer. And third, a self-proclaimed retired stream farmer who posted a video in which he claimed to show how a streaming bot had UMG and Kendrick Lamar used to boost Not Like Us streams in their beef with Drake. Well, let them niggas come into the court and be subpoenaed then. These are individuals who purport to have firsthand knowledge. They're included in our complaint. So they saying Joe Budden's supposed to have firsthand knowledge, Twitter users, and social media whistleblowers. They're included in our complaint, and they are all consistent with the underlying and background allegations that preceded. This is an entirely appropriate allegation on information and belief. And under the authority that we've cited, these are particularly appropriate information and belief allegations when you're dealing with a covert scheme where, in order to complete our proof with the claims, we rely upon evidence that is in the possession of the defendant. That is in the authority that we cited, which also cites cases from the Second Circuit on this point. You're hinging your argument of bots on Joe Budden, random niggas on social media, and a nigga who claims he know how to bot some shit and said, yeah, that's a bot. Wow. We make three other arguments on this that I'll only mention very briefly. The second is that UMG provided financial incentives to streaming platforms to promote the recording and recommendations playlists and search results. And in particular, this is important because it relates to the injury argument, which I'm about to get to. We allege that UMG charged lower than usual license rates in order for Spotify to recommend Not Like Us, meaning Spotify would get to keep more of the royalties from Not Like Us if it were true. And we allege in paragraphs 180 and 183 numerous examples of users who describe searching for other music, including searching for Drake's music, and being directed to Not Like Us both on the Spotify platform and on the Apple platform, and that's quite important in the injury allegation. So they saying when people put Drake's name, and everybody that's used Spotify knows how that works. You could put a song title, you could put an artist name, it's going to give you perhaps the artist or the song title you're looking for, but it's also going to give you relevant suggestions of people related to that artist or who have songs of similar song titles. They're trying to say, no, this was manipulated with an agreement between Spotify and UMG. And they also speak to Apple, which was about the Siri thing, play Certified Lover Boy, and it played Not Like Us, which we've already debunked, we already understand, but they're continuing to hone in on these misnomers, literally in court. Crazy shit here. The last two allegations in this are pay-for-play payola allegations at paragraphs 184 to 188 of the complaint, and the misleading statements that UMG made about the recording, streaming, and radio successes, while knowing that such success was inflated by its deceptive scheme, and that's paragraphs 130, 154 to 155, and 257 of the amended complaint. All of that is entirely appropriate under any pleading standard when considered in context. The second argument that Mr. Ransom made was about the injury element. Mr. Ransom argues that the injury is too attenuated. There are too many steps in between Drake suffering harm and the alleged harm to consumers. That's simply not the case. So as I just explained, as we've alleged in paragraphs 180 and 183, the scheme that we have alleged misdirected consumers away from Drake's music as a result of manipulation of the search functions on Spotify and Apple, and the result is that consumers were misled into streaming Not Like Us rather than Drake's music. We have also alleged that this caused direct financial harm to Drake, not indirect financial harm to Drake, in paragraph 229 of the complaint, where we explain that reduced streaming rates translates into reduced royalties. So they saying that UMG and Spotify came up with a scheme that when you search for Drake's music, Not Like Us would come up, which would ultimately mean less people streaming Drake's music, which would create less royalties for Drake. That's what they're trying to convince people of. So before you get to any argument, the judge interjects once again. Can you explain to me, and I'll express some ignorance as to how whatever algorithm applies to Apple Music and Spotify work, but how is this either the streaming bots or the pay for play related to the notion that if one went on Spotify and tried to play Drake's music, you'd be redirected to Not Like Us? The connection between those two things is not entirely clear to me, and perhaps it's because of my lack of familiarity with how those platforms work. Gottlieb says, so the streaming and bot farm is distinct from that claim, Your Honor. So the streaming and the streaming fraud allegation was sort of the first set of allegations I listed out. The payment of financial incentives to promote the recording and recommendations in playlists and in search results was the second. Those are contained in separate allegations in the complaint. I'm still trying to understand how Not Like Us being in playlists affects Drake. Judge says, so then what is the injury with respect to the bot streaming allegations? What would Drake's injury be? Great question. He says the injury in bot streaming is there is a dilution argument, and there's a sort of streaming to get streaming argument. So the dilution argument is the larger the number of fake streams that exist in the platform, the lower the royalty rate that goes to artists that are not involved in streaming. Judge says, so what you're saying is every single artist on Spotify would have this exact same cause of action against UMG. We see no other artists complaining. Gottlieb says yes, and that's entirely consistent with Section 349. In the Northern Autobahn case that we cite in our papers, there's two cases that we cite in our papers on the injury requirement, recognizing that by giving any person is the language of Section 349 by giving any person who is aggrieved by an injury to a consumer standing under Section 349. There's potentially a large number of businesses, particularly in competitive situations, that can bring claims, but the court has held that that was the intent of Section 349. If you give me 1 minute, Your Honor, I'll get the case so I can make sure I cite it correctly. Sure. So now he goes into this North Shore Autobahn case to try to prove his point. This case is from 2012, and it explains in the section on direct injury how the statute allows for any person to bring a claim, and the question is whether the business that is asserting the claim suffered an injury as a result of the consumer deception. The claim in the North Shore Autobahn case, as well as the MVB collision case that we cite, was essentially that consumers had been deceived or misled by insurance companies in a scheme to take their business to other businesses that happen to be competitors. And as a result of those consumers being misled to go to other businesses, North Shore Autobahn suffered harm as a result of having fewer, sort of less foot traffic or less traffic into its business. That's essentially the argument that we're making here. When consumers are misled into listening to a song when they're searching for Drake's music, he is injured both directly, but when he's also injured as a result of dilution because of less compensation that occurs in the formula from Spotify for its artists. Your Honor, with respect to civil harassment, we can rest on our papers and the authorities cited therein unless the court has questions for me. Judge says that would be great, thank you. Ransom, I'll give you a brief period for rebuttal. Ransom, thank you very much. Now remember, Ransom is representing UMG. He says, I will endeavor to be brief. I'm sure you will hold me to it. Let me start, if I could, with Exhibits B, J, and P to our request for judicial notice. Those, again, are articles that are cited in Drake's complaint. And if I heard Mr. Gottlieb correctly, after discussing them, he said these things in the record. If the court wants to consider them, I think this is a quote. We're fine with it. So I believe that addresses in large part one of the court's first questions as to whether and how it can consider these materials that have been submitted. I believe he said the same as to the song lyrics. When I look, for example, at Exhibit P, and I think about Mr. Gottlieb's characterization of it, I think it also resonates with the court's comments that if the court has these materials in front of it, it can look at them and can look at the entirety of them. So Mr. Gottlieb invoked in Exhibit P the statement, and some of the things have been fact-checked, suggesting that tended to convey a finding of fact versus opinion. That judge jumps in, page 4 of Exhibit P. Ransom confirms. This is page 4 of Exhibit P. And he quoted solely the portion that some of these things have been fact-checked. He failed to read the rest. This illustrates why context is so important. So he's pointing out, even in Gottlieb's argument, that they only were taking pieces out of things without full context. It says, and some of these things have been fact checked, like Baka Not Nice, who's a rapper in Drake's crew who was convicted of assaulting a young woman and who was accused of running a prostitution ring. That's the fact check reference. So he's saying he brought up a portion of a statement about things being fact checked, but he did not go further into the statement, driving home Baka Not Nice and his conviction of assault on a woman and running an alleged, I will say alleged, but convicted for running a prostitution ring. He also overlooks the fact that this article, which they're fine with the court considering, in talking about Drake and in talking about the references in Not Like Us, say things like, these are the speaker's quote. We all know the stories of him going to girls' basketball games, and it's in our faces. Let's talk more about these allegations. So again, he took one little piece of a statement while omitting the rest of the statement that it came from, where they were saying, hey, it's weird as fuck that he be going to these girls' basketball games. Let's talk more about the allegations. That's on page 4 and 5. Let's talk more about these allegations around Drake. Taraka, as you mentioned, there are some things we've seen and heard over the years. And then it refers to the discussion or the history with Millie Bobby Brown and her relationship with Drake when she was 13 and he was 30 or 31. So these articles provide the context that the court can and should consider in our motion to dismiss. So true with respect to the lyrics, and again, the court asked the question about tailor-made freestyle, and you're right. It is conspicuous that tailor-made freestyle is not included in the footnote in Drake's complaint. But it is referenced in these articles that Drake is fine with the court considering, and there's no real question that it's a part of the battle. And again, I think it speaks to the question of context, because yes, I focus on the line, talk about him liking young girls, that's a gift from me from Drake, but the context of that is not even limited to that line. And Your Honor, I'm going to read it verbatim. Please excuse the profanity. This is the entirety of the statement from Drake. So they're not even going to just use the talk about liking young girls. They finna go through his lyrics in their entirety. Kendrick, we need you. The West Coast savior. Think about this shit being read in court, dog. Engraving your name is some hip hop history. If you deal with this viciously, you seem a little nervous about all the publicity. Fuck this Canadian light-skinned dot. We need a no debated West Coast victory, man. Call him a bitch for me. Talk about him liking young girls. That's a gift from me. The rapper that said we don't need lyrics being brought up in court filed a lawsuit trying to bring up lyrics in court just for his own stupid ass lyrics to be brought up in court. That's the context in which Not Like Us appears. That's the background, that's the history, and that's what clearly conveys this rhetorical hyperbole that what you hear in these rap battles is trash talking in the extreme and is not and should not be treated as statements of fact. Very briefly, Your Honor, Mr. Gottlieb says there's no indication of a dispute in Bryan as to the context or connotation of the statements. Bryan is a New York Court of Appeals decision. I'm pretty confident there was a dispute in Bryan. And if the court looks at it, the court reflects that the parties vigorously disputed all issues, but that context was key and that the motion to dismiss was properly granted. Mr. Gottlieb also invokes global networks, which is in their brief, albeit not for the point that he cites, and with good reason. On the pleading standard, motion to dismiss standard, global networks was effectively overruled by Twombly and Iqbal, so it doesn't actually state the correct standard. Very briefly on the Section 349 claim, I think what the discussion with counsel illustrates is the fundamentally indirect nature of any injury or harm that Drake claims. It requires consumers doing a thing, Spotify doing a thing, royalty streams doing a thing, multiple steps, and that is not what 349 is intended for. It is not intended to permit any person who claims, in this case as Drake does, that they were effectively indirectly impacted by some purported customer deception to bring a claim. That will frankly flood and overwhelm the courts in a way that is unsupported by the Court of Appeals' requirement that the injury be both tangible, non-speculative, and direct. Judge says, thank you very much. No actual pushback. Unless the court has questions, I will rest. Judge says, thank you very much, counsel, for your arguments today. They were very helpful. The court is going to request that the parties order the transcript and split the cost among them. I'm going to reserve decision on the motion to dismiss, so an opinion will ultimately follow. So during this oral argument, the judge did not make a judgment clearly, or else this thing probably would have been tossed. So there is supposed to be an opinion which will follow, which if you go through the docket, that opinion has not been submitted by the judge as of yet. Are there any other issues that the court needs to take up today? Gottlieb says no. Ransom says no. Court was adjourned. So y'all could tell me, who do you believe got the better in this oral argument? In my opinion, I feel like Roland Ransom had much better arguments, had a much better flowing conversation with the judge. Gottlieb was getting cut off every time he was trying to say something. The judge was like, how that make sense? What the fuck does that? And what? Are you sure? You trying to tell me what I can't say and can't do at this stage? Look at rule number 201 right here. I can do this anytime. Let's talk about the lyrics. Let's look at the context of the lyrics. Let's talk about the rap battle in its entirety. Gottlieb, no, please. Let's just look at Not Like Us. Song is too big. It's a national anthem. It's a separate entity. Again, don't take my word for it. Replay it again if you need to. Let me know who you think had the better oral argument. Okay? In my opinion, Drake and his lawyers got cooked. But that's just my opinion. All right? Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one. All right? And hopefully we could get back into some music talk rather than this. But I know this is what people want to know. This transcript was released. Had to get to it, man. Can't skip it. We keeping up. I'll catch y'all later, though. Much love and respect.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some batteries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.